Excellencies, honorable speakers, distinguished guests, ladies and gentlemen. First of all, I would like to introduce myself. My name is Pratyush Singh, and I'm currently a third year law student and a member of the editorial board at IJCLP. I will be the moderator for this session today. Furthermore, I have with me Siddhant Pengoria and Arushi Goel here today, who are second year law students and student coordinators for our session. On behalf of the organizers, Chair for Consumer Law and Practice, and the Ministry of Consumer Affairs, I would like to extend my warm welcome to all the guests to the International Virtual Conference on the new facets of consumer protection, challenges, and way forward. In its inaugural edition, the conference aims to provide profound insights into the various facets of consumer law. This parallel session is being hosted as part of this conference and is pivoted on the theme consumer protection and the sale of goods services through social media platforms and fallback liability. On this occasion, I would like to invite the guests of honor to take the reserved seats on stage. Next, I may invite Dr. Pratima Narayan, who is a lawyer, mediator, co-founder of Tech Law Logi Consulting LLP, a law firm based out of Bangalore. Her expertise lies in areas of information technology law, intellectual property rights, commercial contracts, consumer law, and alternative dispute resolution. She is involved in legal consulting and also conducts training workshops on e-commerce and law, intellectual property rights, ADR, conflict management, and communication. She has even authored a book on electronic commerce, legal compliance, which was published by the Eastern Book Company. This book comprehensively outlines the various legal and regulatory framework and compliance for e-commerce players. Dr. Pratima is also an editor and consultant at EBC Learning, an innovative online learning platform where she has offered various courses, including consumer protection law. Lastly, Dr. Pratima is also a mediator with the Indian Institute of Arbitration and Mediation, which is the Indian Institute of Corporate Affairs. Dr. Pratima has served as the legal academia for over 2 decades as the visiting faculty at various reputed law schools and business schools. And lastly, she also runs a legal blog on YouTube, which is her own channel if she would want to speak about that, bringing interesting insights into everyday legal issues like knowing your motor vehicle insurance, online food orders, e-wallets, etc. Dr. Pratima holds a doctorate in law from the National Law University of India University, Bangalore. I welcome you, ma'am, and you can take this.
Thank you. Thank you, Pratyush, and that was quite a longish introduction. Thanks for that. Good afternoon, everyone. Distinguished speakers, esteemed members, and my dear participants. Welcome to this technical session on consumer protection and the sale of goods and services through social media platforms and fallback liability. It is indeed my honor and privilege to introduce the 2 eminent speakers for this session, Dr. Ashish Srivatsava and Dr. Babu Gaur Patil. May I have the privilege to introduce the first keynote speaker, Dr. Ashish Srivatsava. Dr. Srivatsava is a professor at the Department of Business Law and Taxation, Monash Business School, Monash University, Australia. His research areas lie in the areas of law and technology. He holds a PhD from the Monash University in the area of electronic signatures, which is published as a book by Springer. He has many publications to his credit in the area of information technology that's published in renowned journals such as the Information Technology and People, Journal of Business Law, Common Law World Review, Computer Law and Security Review, etc. Dr. Srivatsava has also received several Monash internal grants for furthering his research in e-commerce law, artificial intelligence, data protection, and hazing. Dr. Srivatsava is also an expert in applied policy research. His article, Framework Analysis, a qualitative methodology for applied policy research, has been cited in more than 1,600 papers and is regularly among the top 10 downloads on SSRI. Dr. Srivatsava has more than 10 years of experience in teaching commercial law, marketing law, and IT law to business students at the Monash Business School, and his research and supervision interests include e-commerce, cybersecurity, e-crimes, and legal issues in cyberbullying and hazing. Welcome, Dr. Srivatsava.
Thank you, Pratima. I didn't know that the whole thing would be read out, so I should next time I will make it a very small one. Hello, everybody.
Wonderful.
Yes, sorry.
Dr. Srivatsava, I'll just take one more moment to introduce the
Yeah.
second keynote speaker, and then
Yeah.
we take the
Yeah.
session forward. Our second keynote speaker for the session is Dr. Babu Gowda Patil. Dr. Patil is an associate professor at the VM Salgaonkar College of Law. He worked as a director for Consumer Rights Clinic and implemented projects like advertisement targeting children and green squaddies. He's also worked on some really important and interesting projects like implementing laws relating to the sale of firecrackers and the safe celebration of festivals. He has contributed to the development and implementation of the child adoption program of the central government in the capacity of member, advisory committee, Central Adoption Resource Authority, that belongs to the Ministry of Women and Child, Government of India. Dr. Patil holds a PhD from the Goa University on right to education and employment of persons with disability. Presently, he is working as a director of the Center for Disability Rights and working for the implementation of national education policy as the director of internal quality assurance cell of the institution. Warm welcome, Dr. Babu Gowda Patil. And over to the technical session, and may I call upon Dr. Srivatsava to take the session forward. Thank you.
I'm so sorry to interrupt you, sir, but just for the participants there, after kindly try and not interject the speakers when they're talking. And if you have any questions, feel free to put them in the chat box and specify which speaker is it directed to, and we can take it up at the end of the session. Thank you.
Thank you very much, Pratima, and good afternoon to everybody in India. And it's around 5:40 here in the evening. Just a little bit about myself already, although you have said that I have been here since the last 19 years, and I have done my law degree from Banaras Hindu University, and thereafter I was in Delhi for a few years. So I can see that all of you are experts in the consumer law and the consumer issues related to India. And as far as I have been reading about consumer protection in India, it has taken a lot of with the new Consumer Protection Act as well as the e-commerce rules. A lot of things are happening in India, and I'm sure it's a challenging time for the regulatory body, that is the consumer CCP, that is Central Consumer Protection Authority. So what I would do is I will just give you briefly as to what is happening in Australia, and that may be of use, or that may be of some interest to all of you there. In Australia, we have a body called Australian Competition and Consumer Commission that looks into issues related to competition law and consumer related issues. That's a very active body and has actually issued a lot of infringement notices, as well as taken people to courts or businesses to courts for not complying with the Australian consumer law. Our Australian consumer law is a part of Competition and Consumer Act, which was passed in 2010. And a section of that act is called Australian Consumer Law. And that's what, to some extent, I would be focusing on in today's presentation. So I will start with sharing my screen. Give me 1 minute, second to. Can all of you see my screen?
Yes, sir.
Yes, okay, thank you. So, starting from social media platforms, and of course, just like India or anywhere else in the world, social media platforms have taken the way we communicate, as well as the way we interact with our peers. And now, of course, business is taking advantage of the social media. As I was saying earlier, with regard to the regulatory body in Australia, it is the Australian Competition and Consumer Commission. And what they have found is that over the years, the number of scams have actually increased through the help of because of social media, or the scammers are using social media as for any kind of consumer related scams. And the target here are people who are below 25 years of age, and mostly it is about fake online stores and sale of fake tickets for the events. If you look into this slide, you will see that from 2019, so Scam Watch, which is also a part of the regulatory body, what they found is that social networking was on number 4 with regard to the amount of money that has been lost and the number of reports that has been made to Scam Watch. In 2020, it moved on to number 3. In 2021, it moved on to number 2. And till in October 2022, it has reached to number 2. So the scams were earlier being targeted through emails. So email, it's no longer emails, but it has moved on to social networking sites. Not even internet, social networking sites has become number 2 on the list as far as scams are concerned, as far as amount lost are concerned. The number 1 has for the last few years been phone, where people are called on their mobile phones and on one pretext or the other, and scams are involved through the use of phones. But social networking site has now become number 2 on the list. Now, some of you may be aware of dark advertisements on social media. What it is something very interesting, and a lot of research is being taken place in in Australia as well. What dark advertisement means is that the advertisement is targeted towards a particular user or towards some users on the platform. So what I can explain to you this way, that the ads that you are seeing on your social media is different from, say, your sister, your mother, or your father is seeing on their social media. And that advertisement is there for a certain period of time, and then it disappears. So unlike advertisements which, like on television, where everybody sees the same advertisement, or that it used to be, say, 10 years back, that everybody used to see the same. If you open Times of India, you see the same advertisement. Now, the advertisements are targeted on the basis of the data that has been collected from you when you registered yourself to that social media platform, and depending upon your browsing history and depending upon the data that you have provided to the social media company. So what it means is that, say, if you are 40 years old, if you belong to a particular race or a particular tribe, or if you belong to a certain category, the advertisements can be targeted towards you, right? That advertisement would be different from what it has been sent to somebody else. So in the past, what Facebook has done is that it has allowed where people can advertise for housing as well as employment based on race, gender, and age. So this is where the issue becomes very complex and complicated. Sometimes it may become illegal, and also it is unethical. A simple example that I can give to is, suppose in Australia, there are indigenous people who have alcohol problem, right? It is not illegal to provide them alcohol, but it is generally considered unethical because they have an alcohol problem. Now, if through their browsing history, through the data that has been collected by social media, for example, Facebook or Twitter, they target the ad of alcohol to those people, right? So this is where it is a big issue, and a lot of research is being taking place as to what extent social media can regulate this advertisement and whether they should be responsible for this act or not. Another research that has happened, and I'm more than happy to share my slides or send it to anybody who's interested, is about the transparency issue. So whatever advertisements or whatever data has been collected, what advertisements are on the platform, how long those it is in the register of those companies, that what advertisements they have been promoting on their web pages. A study has been done by a few people in Australia. It's called How Dark is Dark Advertising. And what they found is that these companies, most of them lacks transparency, but the worst is TikTok. TikTok doesn't allow any observation of advertising on their platform. Meta is so far the best as far as transparency is considered, but it goes down, and Twitter and TikTok are the least transparent social media platforms in Australia. Now, let us look into some interesting cases that has recently happened, or news that has recently come in. Australian Competition and Consumer Commission has recently, what they have done is they have filed a case against Meta, that is a Facebook and Instagram. And why they have filed this case is, and their argument is very interesting. What used to happen is that on social media platforms, especially Facebook, there were advertisements available where these people, they are well-known public figures. David Koch, who is a TV presenter and also a financial expert, former Premier of New South Wales. In Australia, there's no chief minister, it's called Premier. So former Premier of New South Wales, the capital of which is Sydney, and businessman Dick Smith. What it said is that these celebrities have endorsed cryptocurrency and money-making schemes. So anybody who is looking into saying, look, Dick Smith, David Koch, and Mike Baird are actually promoting this money-making scheme, I should also invest in that Bitcoin or other cryptocurrency. Now, these celebrities or these public figures never endorsed this cryptocurrency. And what they did was they even complained to Facebook that we are not involved. Please remove these advertisements that are coming on Facebook. Now, despite that, that is the Facebook or Meta company, didn't remove those advertisements. And one person actually lost $650,000. Now, the Competition and Consumer Commission, ACCC, instituted federal court proceedings against Meta, alleging that they are responsible for these false and misleading advertisements that they publish on their platform. Now, the question is, what is the argument of ACCC? Now, ACCC is saying that Facebook uses algorithms. And as I was saying to you earlier, that Facebook uses, there is an algorithm and also there's a behavioral ad technology. And what it means is that the advertisements are target to users, specific users who are most likely going to click on those links. So because Facebook is actually interfering with the advertisement as to making sure as to whom it should be targeted, at the same time, through their terms and conditions, they have assured that Meta would be preventing scam and promoting safety. Despite that, the advertisements are continuing, despite being said to Facebook, not through court order, but Facebook being said by these public figures that we are not involved, the advertisements have still been continued, and it has continued over a period of time. It not only caused loss to consumers, but it also caused damage to reputation of these public figures. And Mr. Rod Sim, who was the ACCC chair, and in the last day in his office, he said that if the regulatory body is successful in the federal court, then social media platforms like Facebook would have to rethink their approach with regard to advertising, as to what they accept on their platforms and the extent to which they apply their technology to profile targets and match users and advertisers. And why it is important at this stage, or why it is so the regulatory body is so much involved here, is because through advertisements, Meta actually earns around $115 billion, right? So it's a huge amount of money, and they want that it should be a fair play on part of Meta. Now, another interesting case, not linked to consumer as such, but linked to the issue that we are talking today is with regard to a very well-known case, that is Fairfax Media versus Nationwide News Proprietary Limited. And this is the case of innocent dissemination, where we talk about intermediaries and they are not publishers, and all those arguments that we have, that they should not be held liable because they are just putting the content on the platform, and they are not involved in any kind of the way that content has been put on the platform, or what content has been put on the platform. Now, in this case, what happened is the High Court of Australia, and before we move forward, just to let you know that the High Court of Australia is like the Supreme Court in India, it is called. And so the highest court of Australia is called the High Court of Australia. And by a majority of 5-2, they held that the owners and administrators of Facebook pages, like, for example, if Times of India has a Facebook page or Indian Express has a Facebook page, they can be held liable for defamatory comments made by third parties on their pages. So anybody who comments to that post, say their Facebook has a Times of India has a Facebook page, and there any comments are made, and that comments are defamatory in nature, then in that case, that particular publication can be held liable. The appellant here, the newspaper company and the news company, said that, look, as far as publication is concerned, defamation is concerned, there must be some intention involved, and this is the law since 1928, that a common law position, that there should be some intention to publish a material, and then only the person can be held liable. And the High Court of Australia says, no, there is no requirement of intention to publish. Merely by participating in the act of publication, it is sufficient for the individual or business to be held liable. What it means by that is that if any publication company, they want to make a commercial gain out of it by having their page on Facebook, and then after that, somebody based on that news item, whatever it is, makes any defamatory comments, then in that case, that publication can be held liable. So if, for example, just hypothetically assuming XYZ newspaper contracts with Facebook for creation and ongoing provision of the Facebook pages, and then they are posting the content on Facebook pages, which gives users like you and me the option of commenting on the comment. And if that comment is defamatory in nature, then in that case, that publication XYZ can be responsible for defamation. Right. So this is a very interesting case, a very well-known case that happened in last year, and it is going to affect the way how defamation laws are going to be drafted in the future in Australia. Now let's move on to the advertising position. Is what advertising position we have, or the guidelines that Australian Association of National Advertisers have. One is the ethical issue which are not legally enforceable. These are guidelines. And what it says that whenever any kind of advertising or marketing takes place on social media, there should be hashtag such as #ad, #sponsored, which can be used in conjunction with #ambassador or #collaboration or #paid partner. If whatever has been advertised, it is not consistent with the promoted product, then Australian consumer law says a very simple section, very laid down in a very layman language, that a person must not in trade or commerce engage in conduct that is misleading or deceptive, or that is likely to mislead or deceive. If this happens, then in that case, it's a violation of Australian consumer law. Now, as far as influencers are concerned, over the period, what has happened is that no longer celebrities are the influencers. Now consumers have become influencers, like some of the YouTube people in India, they have now become influencers. And why they have become influencers is because if we see, for example, any person like a celebrity like Amitabh Bachchan or Shah Rukh Khan, we know that it's maybe this person, we don't trust that that much, that person, with regard to advertisement or with regard to any particular product. But if I and you, who are, say, a YouTuber, and then we say, look, we use this product and this is very well-known product, it helps to achieve whatever they are saying, then in that case, that information seems more credible. So consumers have now become influencers. So they are influencers as well as consumers. So their e-word of mouth that they are doing, there is a blurb or some kind of advertisement also involved in that. And if it is an advertisement which is sponsored by brands and companies, then they should have a hashtag as it is an advertisement, it is a sponsored ad. If they don't do it, then it is misleading and deceptive conduct on their part. Similarly, with therapeutic goods, like, for example, in India, from Indian point of view, say, for example, Patanjali goods and all those type of goods. In Australia, we have TGA, that is Therapeutic Goods of Australia, and they have a code. And what they say is that if anybody, any influencer or social media influencer, if they make a testimonial, and what they say is testimonial is basically a statement made by a person who claims to have used that goods. If you have not used that goods, you are not basically not making a testimonial. Otherwise, it's some kind of, you can endorse, but it is not a testimonial. And testimonials are prohibited in advertisement goods if they are made by persons who are engaged in the production, marketing, or supply of the goods. But at the same time, now what they have said is, if an influencer receives valuable consideration, which can be monetary or it can be non-monetary, it can be gift as well, then such type of testimonials are prohibited from any influencer if he takes any money, he or she takes any money, or any kind of gifts or discounts or any future promise of future benefits from that particular business or company. Now, apart from goods, apart from normal influencers, there is another term that has been used or being used these days, is called financial influencers, where people come and say, look, invest in these shares, invest in the crypto in the next 6 months. This is how it is going to happen. Now, recently, the Australian Financial Services Corporation has also come up with some guidelines, and what it says is that any person who's an influencer and trying to promote some kind of investment strategy, then in that case, that person has to be a licensee under the Australian Finance Corporation, and whatever content has been laid down or whatever has been mentioned, it should be accurate and balanced. And if they don't do it, it is misleading and deceptive conduct on the part of Australian consumer law. A couple of cases. One case which I can briefly mention here is a company called Allergy Pathway. And Allergy Pathway was actually a notice was sent by Australian Competition and Consumer Commission. They were making false claims about their products, saying that the product can treat allergies using muscle strength indicator technique. When ACCC brought an action against them, they went to the court and they gave an undertaking to the court that we will refrain from making or publishing or causing to be published such false claims. So we will not make any such claims that muscle strength indicator technique allergies can be solved through that. But thereafter, what happened is some of their clients, they actually posted on their Twitter page and Facebook wall page some comments about the products which were actually misleading and deceptive. And the matter once again went to the court, and the company said, look, we are not promoting it. These are the clients. They are posting on our Twitter page, on our Facebook wall. Although it may be misleading and deceptive, but it is not we who are involved, it is not us who are involved in that. And the court said that, look, you are not involved, as you were not responsible for the initial publication. It was a third party, we agree to that. But as soon as you came to know that it is a misleading and deceptive or a false claim that has been made about your product on your web page by a third party, and you let it state that content be there on the website, you have actually caused it to be published. And therefore, you have breached Australian consumer law in that regard. Few other cases. One is with regard to panel company that published YouTube videos, which were like customer testimonials, but were actually recorded by paid actors. And the court says it is misleading and deceptive conduct. A lady, Mrs. Powell, used to, in her YouTube video, she would used to say it's a champagne, but it was a sparkling wine, and the champagne company or the body that is involved in selling and production of champagnes, they filed a case, and the court said, look, you cannot do that. And the third one is Mr. Turpey, who was paid for a nasal spray, and he was in an advertising campaign saying that it cured his sexual impotency. But as I said earlier, in testimonials, you can say only thing that you have, if you have used, and the testimonial said that I've used it and it worked. No doubt he used it, but it didn't work, and that's why it was a false claim, and therefore the court said that it is a misleading and deceptive conduct on the part of Advanced Medical Institute. So these are some of the developments that has happened over the years, and the latest development is that the regulatory body, Australian Competition and Consumer Commission, has come up with an issue paper in August 2022. And what they are looking into is the relationship between social media platforms and consumers. Apart from other things, social media platforms and consumers are something of interest to the regulatory body, and they are seeking information, views, and experiences of people like us, as well as business, when dealing with social media platforms. So once it comes out, I'm more than happy to provide more details about it. But specifically, what they are looking into in this issue paper is, are businesses impacted by potentially misleading or deceptive claims through display advertising, right? Especially where influencers are involved. What are the process for consumer and businesses to report misleading and deceptive conduct by social media platforms? If there is a misleading and deceptive claim, how can consumers and businesses report it to that platform? How effective are these processes? If you complain, does it really work? If you complain to Facebook that, look, this is a false claim. And finally, are consumers faced with potentially misleading? Are we facing this misleading and deceptive claims through advertising on social media platforms? So a lot of things are changing. Businesses are taking advantage of social media. The laws to some extent has able to catch up, but there's still a lot of work that needs to be done, whether it is in Australia or any other country, including India. But the things are working, the regulatory body is working, and also the courts are looking into the matter related to how social media platforms, if they have breached the law, and how to protect consumers if they have breached that particular law, particular provision. So I think that's all from me. Please feel free to contact me at the address. Anybody who is interested in the slides, I'm more than happy to pass on to Professor Patil. And for any questions, any queries, please feel free to contact me. Do not hesitate at all. Thank you very much, and I appreciate your time.
Thank you, Dr. Srivatsava. And request the participants to continue to post their questions on chat. We'll try and take as many questions at the end of the session. And may I now call upon the second keynote speaker, Dr. Patil, to present the keynote. Thank you. Over to you, sir.
Yeah, thank you, ma'am. Thank you very much. I hope I'm audible.
Yes, you are.
Yeah. Thank you. Thank you, Mr. Srivastava, for covering advertisement and the online thing, because I was listening to you by holding my breath, because if you overlap on our topic, then I would be left with nothing to speak about. So luckily, we have.
Right.
Yeah, please.
I hope I have not covered your part, because that's why I confined to Australia so that it doesn't cover.
Yeah. Thank you very much. And I congratulate Ashok for his lovely book that he has written and inaugurated in today's program, and also I'm very happy to see many of the district consumer commissions members and presiding officers are attending this program. And this is something which is going to be the future, because online business, advertisement, and these are going to be part of, it's going to remain with us, because I am of a strong belief that one thing that cannot be stopped in this world is technology. You cannot stop it. You can only delay it, but it can never be stopped. And if you are not abreast with the technology, then slowly we are going to be fossilized. So rather than getting fossilized, put your head down and learn the new ways of businesses and other things. So what I have done in my 20 minutes that has been allotted to me, I'm just trying to decipher the topic that has been kept as for this discussion, that is consumer protection and sale of goods and services through social media platforms and fallback liability. That's quite a long title. What I have understood here is there are three technical things that we need to concentrate upon to understand the area of our discussion. Consumer protection is going to be the first one, because what I feel is with a lot of effort, and we tried ourselves, and we fought ourselves, and came up with some law to protect ourselves in a physical world as a consumer. And when we are relaxing that our rights are protected and there are commissions to take care of our rights, now business and the technology, they came up with a new task, that is virtual world. Now we have to venture into virtual world, and there we need to protect our rights. So consumer protection is facing a new challenge, and that challenge is from virtual world. Second point which attracts my attention is social media platforms. So the title contains this word social media platform, but when you browse through the laws of India, European Union, and even Australia, we don't find this word in our legal jargon. In law, we use a different terminology, and I understand the reason for this disconnect. I am going to explain that in next minute itself. Then comes the third one, is a fallback liability. Now, fallback liability is a kind of a necessity in the present virtual world. I do see some historical connect in this, that when we talked about vicarious liability in the law of torts, so where act of an employee, the master is held liable. So there, what we are trying to do is we are trying to make someone liable for none of their fault, but creating an opportunity to create a fault. So that's an interesting point, that the fallback liability has its a kind of a seed in vicarious liability, and as well as it also has a seed in something called as Rowland versus Fletcher rule, that is a strict liability rule. Now, why I say that it has its roots in strict liability rule is because when industrial revolution took place and there was a complex business plan was created. So now earlier, the manufacturer used to sell, and he has a small shop, he used to sell it, and then used to earn profit from that. But due to industrialization, we have too many intermediaries. There is a manufacturer, then there is a distributor, then there is a wholesaler, then there is the retailer, and then there is a consumer. So between the manufacturer and consumer, many people started intervening. So that's where the strict liability concept was created in that case, the Reliance versus Fletcher case. Now, fallback liability is again a necessity, so that in the virtual world, the interest of the consumers could be protected. So these are the three technical words which I feel that needs to be understood to understand the today's session. So what I have done is I have come up with around 5 discussions, and I'm going to quickly go through those 5 discussions so that we will have some understanding, and later we'll have interaction with the participants. So when we talk about social media platforms, now, as I mentioned, the social media platform is the word which is missing in the legal jargons, because in law, in European Union and even in India, we use the term like core platform services. Gatekeepers is another term used. In India, we use the word social media intermediaries. And then we added one more component called significant social media intermediaries. Then we have a marketplace e-commerce entity. So there is a word used by tech world, and there is a different word used by legal world. The reason for the disconnect is to create, because anytime there would be new inventions. So if you use the word what tech world is using, then we may have to amend every time and insert a new activity. So I can remember, if I may be permitted to speak about the word cheating. It is defined in the penal law. It has never been amended. But cheating, every 15 days or maybe every week, there's a new innovative way of cheating is found in this world. So, but there was no necessity to change the definition of cheating because it is a holistic definition. Similar attempt has been made here by avoiding tech words in the legal jargons. Here we use the word in a different sense. But when we talk about social media platforms, there are n number of platforms available where consumer rights are either directly or indirectly impacted. So for example, e-marketplace. So Amazon, Flipkart, Pepperfry, .com, on Mintra. Now, these are all e-marketplace. They are social media platforms. Why I call it as social media platform is because that word itself is not defined anywhere. So anything, everything where society interacts with one another becomes social media platform. Objective may be different. The object here is market, sell and buy. Similarly, there is online search engines. They are also indirectly impacting the rights of the consumers, because Google, Bing and Yahoo, they do impact, because as morning the chief guest was mentioning about algorithms, the different algorithms are used to influence the person's search. Then we have social networking services like LinkedIn, Twitter, Facebook. So Professor Srivastava was mentioning about Facebook being dragged into litigation because it was used for business. So they are also impacting the consumer rights. Video sharing platforms, YouTube and Vimeo, yes, they are also consumer impacts the consumer rights because they are influencers who influence the consumer's choice. There are interpersonal communication services like WhatsApp, WeChat, Messenger. They also impact because many people tend to do business within their community, within their group, and they also have to have some kind of responsibility on that. Then we have operating systems like Android, Mac, Windows. So the question here is how operating systems impact the consumer rights. So I think a few days back in India, Google was the compensation was demanded from Google because 97% of Indians use Android, and Google had a contract with Android to use their platforms as default platforms like Google Map, YouTube, Chrome. So that they felt that the consumer's right to choose has been impacted. That's one part of it. Another part of it is competition. It's a violation of fair competition. So therefore, even operating systems can impact the consumer rights. Web browsers, they also, like Firefox, Chrome, they also can impact the consumer rights. Now comes the future. Now we have virtual assistants like Alexa and Siri. Now, these virtual assistants, what we see now is only a tip of the iceberg, because artificial intelligence is going to be the future. And when artificial intelligence takes over, it is someone else control our choice. Because artificial intelligence works based on certain predetermined formulas. And the formulas would be determined based upon who pays them. And based on that, they are going to influence our thinking, influence our choices. So therefore, when we say social media platform, there are various platforms which affect us directly or indirectly. So now let me move on to the third discussion. The third discussion is on fallback liability. So as I was talking about fallback liability, there is one difference I can see from the history of law. Initially, the consumer rights were the advent of judiciary. Through judgments, judiciary created these consumer rights. And later, after lapse of maybe 50, 60 years, there was a legislation. So it was a judiciary which responded first. Now the present day, judiciary is in the forefront, especially if you look at India, the National Commission on Consumer Rights, state commissions, they are very vibrant and they have taken up decisions in favor of consumers, especially in the virtual world. But legislatures are not falling behind. Now, if you listen to the morning's lecture by the chief guest speech by our chief guest, he was mentioning about so many things are going to come up in the form of rules and regulations. So that is where the difference I can see here is legislatures are running shoulder to shoulder with the technology. They are not lagging behind. So that's one difference I can see. So how do you justify the fallback liability? Now, let me draw your attention to one small discussion. Like if I go to a mall, the mall, say it's a marketplace. I go to a shop in the mall and buy something. How a mall can be liable if I've been cheated? Because absolutely they have no control over my choice and my dealing with the seller. So therefore, mall cannot be held liable. So when mall cannot be held liable, how e-marketplace can be held liable? How Amazon can be held liable? So there need to be some justification on the fallback liability. So the justification lies in the laws that has been already been framed. So if you look at the logical deduction, now say for example, a person with vision impairment, a disabled person, he walks into a mall. He's supposed to go to shop A, but because of lack of direction, lack of friendly atmosphere and the structure, he ends up in a shop B and buys a wrong thing. Now here mall should be held liable. The answer is yes, because they are supposed to provide a proper guidance. They are supposed to empower the person with disability to reach the destination, which is not been done by them. Now, same logic is applicable to a common person, a normal person in the virtual world, because the virtual world is an opaque world. We don't know where we are going and what we are searching. Because everything is controlled by these platforms. So there is a lack of understanding. There is a lack of clarity. So therefore, because of this lack of clarity and understanding, there is a need for creating a liability on these platforms. Otherwise, the legislatures, the executive cannot monitor them. The citizens end up fighting an unending fight in the court. So this idea of e-platform creating a liability on them, it becomes a savior. So if I look at the some of the liabilities, so first thing is the law has made the marketplace, that is the Amazon, Flipkart, must ensure accuracy of the goods. So that means if someone is selling a goods in their platform, they must ensure accurate description of the goods. 7-8 years back, when I was supposed to buy a bag, there was absolutely no description, only the name, and then the color of the bag was displayed. Nothing else was there. Now they have to give an accurate description, otherwise Amazon would be held responsible. Similarly, details of the sellers, robust grievance redressal mechanism by the platform has to be provided. Ma'am, I'll take another minute and I'll wind up because I think I am overshooting the time. So I won't take much more. Similarly, the principle of due diligence is going to work against these platforms. So due diligence should be exercised by the seller and also a platform which is providing them the space. So Hello Travels was a travel agency in India, and it was just a platform where it was arranging a meeting between the consumer and the travel agents. And when the consumer was cheated by the travel agent, the platform was held liable. Now that's what the fallback liability is all about. So I feel we are working towards the consumer, and still there is a long way to go. At present, I cannot say that consumer is a king, but definitely an informed consumer is a king. Thank you very much. Thank you.
Thank you, sir. Over to the student coordinator.
Hi, ma'am. Hi, I'm audible.
Yes.
Right. So that was a very insightful session, Mr. Srivastava, Mr. Patil. Like, I personally learned a lot, and we will now open the floor for questions. So if any of the attendants has any questions, they may raise their hands, or we have received a set of questions. I'll move on to that if there is no person willing to ask a question right now. Right. So if meanwhile, while I'm asking, anybody has a question, you can put it in the chat box or raise your hand and we'll recognize you accordingly. So the first question I had for Mr. Srivastava. So you talked about Australian law, which was very insightful. And I was just wondering as to, how much of it is relevant to Indian law. So in India, we have two very different set of laws, one focusing on the consumer aspect, and we have a competition law separately. The problem somewhere arises when these two overlap. Let's say in the cases of unfair trade practice, I have been cheated because of unfair trade practice. And instead of cheating, let's take the case of Facebook, the example that you were mentioning. Now, a uncompetitive practice by Facebook is also liable under the Competition Act, as well as me as an aggrieved consumer can also file a complaint under the Consumer Redressal Forum. Do you think this will pose a challenge? The overlap will pose any kind of challenge? If so, how can we solve this?
I think what Australia has done is that we have a same body. The regulatory body is the same. It's called Australian Competition and Consumer Commission. In India, it is different. I think Competition Commission of India is separate from CCPA, right? So that's, I think my suggestion would be that these bodies should work together. They should be merged together. And that's how it is, because ultimately it is the regulatory body. It's not possible for consumers to go, say, for example, if I lose 500 rupees of a shirt is not up to the standard, or say something is also TV is not working. It is the regulatory body's job to make sure that businesses don't cheat, because businesses are in such a powerful position, especially big businesses, that consumers don't have. Even if you go to consumer forum, I don't know how many years you will get, and is it worth going for loss of 500 rupees or 1,000 rupees? So that's where the regulatory body comes into play, that if businesses are taking advantage or trying to cheat the consumer, then there are hefty penalties involved. And a very good example that I can give to you is that few years back, ACCC, that is once again Competition Consumer Commission, took Nurofen to, all of you know Nurofen. Nurofen is like ibuprofen, Nurofen, and they took Nurofen to court on the grounds that Nurofen were selling tension aches, headaches, capsules, almost 1.5 to twice the price of a simple Nurofen tablet, and there was no difference between the two tablets. And they were able to get away with it. So an ordinary consumer does not have time, nor has the inclination, nor would like to go. But that's where these regulatory bodies can come into play to assist. Not only, it's only also an unfair practice on their side, where you are selling, say, for example, anything which is more expensive, but the product is exactly the same, which is $2. And they don't mind it because they pay the fine. The thing is that they pay the fine. If they pay 5 million, 10 million, doesn't bother them. Procter and Gamble, it doesn't bother them 5 million, 10 million. They have already made 30 million or 40 million from that sale. So that's where the regulatory body and the court should come in with hefty penalties, with especially big organizations, so that they don't do it in the future, as well as a lesson for other businesses.
So may I add to what Professor Srivastava was mentioned? See, when we talk about fight for the rights, see, we also look into the benefits. So as Professor was mentioning, it's very true. When the benefit at the end of the fight is 500,000 rupees, we prefer to forget it. And that's the thing which the business houses are exploiting. They don't cheat you with lakhs of rupees because we get an incentive to fight for it. They cheat you with the pittance so that we don't have an incentive to fight. Now here, where the authorities should come up with a mechanism which already it's operating in India called Ingram, where you should not end up fighting for your rights. You are only an informant, and the fight is taken over by the state. So they fight for you and get the justice for you. Now that's the system which works for consumers. It should not be taken up as any other civil litigation and bring that system here. It should be a little different from them. Thank you.
And one thing which I add, I think the new law, I'm not sure about it, I think the new law of India is better than Australia in one sense, that I think in Australia, it's only the penalties or infringements that can be imposed. A person cannot be sent behind bars. But if that is the case where a co-director, as soon as you start seeing director, you go behind bars, you start seeing them behaving properly. Because as so far as infringement is concerned, it's peanuts for them. They will make money the next month or so.
So I had a personal experience with this because there is a provision in Factories Act where a person is injured or something, they should be fined. But if the second violation is imprisonment, first violation is 5,000 rupees fine. And a company fought up to Supreme Court and it didn't want to pay that 5,000 rupees. It's not about 5,000. It's because the first box is ticked. The first violation is done, and second violation they will be in the bar, behind the bars. So that's why the punishment works better, especially for business world.
Right, Mr. Patil and Srivastava. That was very insightful for all our viewers here. Ingram, which Professor Patil was talking about, is the integrated grievance redressal mechanism, an online grievance redressal mechanism that the Consumer Ministry come up to. So now for raising a complaint, you need not go to the courts, you need not go to the district consumer. You can simply find an online complaint. That is a very helpful resource. And Mr. Srivastava, your point on the deterrence effect that, you know, higher punishments, imprisonment creates is very insightful. And of course, it tells us how many countries can learn also from India. It is not just India learning from abroad, it is other countries can also learn. I have a second question also, which is directed to both our keynote speakers today about the data protection laws. Because recently, and both of you talked about, Professor Patil talked about Alexa, Professor Srivastava talked about Facebook and other such firms. So the data protection laws and consumer law, the intersection has come into recent discussion, especially because the new draft of the personal data protection bill that had earlier come in 2019 and was reintroduced a couple of days ago, that has come again. So what are your views on the data protection laws? How can they be strengthened and how can they be given a consumer angle so as to, you know, make our consumer protection system a bit more more holistic? I'll start with Professor Srivastava and then Professor Paul.
So as far as Australia is concerned, it's this privacy was never an issue. Data protection was never an issue for any country until this GDPR came into existence. Everybody woke up. What is this GDPR? So General Data Protection Regulation, because it is such a, it's the branch, it's such a law that if you're dealing even with some minute thing where European Union or business is involved, then you have to fulfill their obligations. And that extends to any country. Even I'm doing some work with AI in Bangladesh garment industry. There also they have to fulfill the data protection. So now every country, they want to make sure that they are fulfilling their data protection obligation, because they have to match that GDPR obligation. Otherwise, it's going to affect their economy. It's going to affect their business. So to that extent, I think Australia hasn't got any. We have a Privacy Act, but still it's lacking. There are certain guidelines provided, but there is no data protection law as such. But at the same time, what they have tried to do is that they have tried, as Professor Patil was saying, that with the word cheat, he was saying cheat is cheat, whatever way you do. Same thing they have done is that if you are trying to mislead or deceive, or if you are trying to take advantage of such a situation, so they are taking that consumer law into picture, and they are using that consumer law to actually protect individuals from breach of data. I don't know whether you people know, but Medibank, which is our biggest private insurer, Medibank, that data has been hacked, and I think around 10.2 million people's data has been hacked, including mine. And they are asking $1 per person, but so far the government has said no. So they have started actually releasing those data, or started with celebrities. Say, for example, somebody has got an abortion done, because it's a data, medical data, right? Or if somebody has done any other thing. So these private data are being slowly released on the dark web, pressurizing the government to. So once again, is the question of technology, the data protection, to what extent data needs to be protected. And two things which is very important now that we are talking about data protection in India is that companies should know how much data you need. Okay. Do you need all those information for your business or for providing me that services? And if you take that information, whether you are using appropriate technology and reasonable level of technology to protect that data, or protect that data, my data. So why do you need my marriage certificate, or any other date of my marriage, or date of my son's birthday? Why do you need, to what extent you did? And that's where the government is trying to focus on. It's not that Amazon says, okay, you fill, or anybody says, okay, you fill in those details, name, address, so and so. Do you need those data? You are just collecting it for business purposes or for advertising purposes, the first. And the second is, if you're collecting that data, first is it should be reasonable. It's the only thing, only what you require you collect. And then to what level your company is, whether it's Amazon, depending upon your company, how big the company is, whether reasonable protection has been provided to that data, you have taking that. And these two are the main questions that sooner or later, I think India will face as well with data protection, right? So whether the companies are willing to invest that amount of money to protect the data, and if it breaches, then what happens?
Right.
Sorry for Dr. Patil. Sorry to Professor Patil. I took so much time.
Okay, no problem, sir. The Professor Srivastava spoke at length about data protection, and if not all the listeners here, but at least on behalf of some of them, I can mention that we don't understand the importance of this privacy. Because if they know about my name, if they know about my recent purchases, if they know about my stay, where I stay, in what way it's going to impact me? Because that's the idea of privacy, or that's the idea of data which the common man has. But one thing we should realize that we were colonized by Britishers because we did not value our land. Because that time when they came to India, they in exchange of a necklace or maybe a pearl, they got land in exchange of that. because land was cheap and we never understood the importance of land at that time. And we were colonized for 200 years. Now we have reached a stage where a nice, cute cat video comes up on the screen in Facebook, and they ask for your name, your email, and other thing. We gladly give it because we want to see the cat, without realizing the importance of privacy. Because then onwards, they start controlling you. This is one aspect of it. But when we talk about the data protection of law, which Siddhant has raised, it is more to do with the state rather than the private companies, because private companies anyway, they are governed by different laws. But when the state collects the data, how it protects another thing, because I do see some misuse of the data going on nowadays, because state do not have a mechanism to protect all that information. When the state loses it, that information, how business people and how then we talk about the influencing the elections, and all these things can happen when the data is lost. But one thing we should realize is that our personal information is the most valuable information, which we should keep it near our chest and never reveal to anybody. Thank you.
Right, Dr. Patil. That was a very insightful. It is interesting you brought out the cat example, because that connects to Dr. Srivastava's point on dark ads. Because if I'm not wrong, these matter a lot. And that was something very interesting that stood out to me from Professor Srivastava's point about dark ads. Because in India also recently, the literature on dark patterns in general is coming out. And many people are trying to figure out how to resolve to them. So dark ads is just one aspect which Mr. Srivastava talked about. We have other such stuff also. So to all viewers, one example that I can think of is like, so let's say when we want to get rid of a subscription, we have a Netflix subscription and we want to get rid of it. It takes us a very long process to get rid of that subscription if I don't want to resubscribe. This model, this strategy, this algorithm that it's going to take you a lot of time is one of the dark patterns. So it'll be very interesting to see how, because these activities are going to increase, people are becoming smarter, technology is getting smarter, these activities will increase. Many people have proposed the solution of regulatory pluralism, wherein you mix data protection laws and consumer laws and competition laws and target this. So it was very interesting that both Professor Srivastava as well as Patil sir talked about this. Just on that, I would like to thank both Mr. Srivastava and Dr. Patil for such an insightful and enriching session today. One thing. So there is a new question on the chat. We will take this as a last question and then we'll close as the session is just about to get over. Mr. Vijay asks, what is buying parallel imports? And this question is directed to Professor Srivastava.
Actually, very truthful, I'm not sure what parallel import means. Parallel import, Professor Patil, you would be aware. Parallel import. Parallel imports basically.
May I intervene?
Yeah. Pratima, please.
If it's okay.
Yeah, sure.
Parallel imports of what we have heard of is mostly in the context of intellectual property rights, where there is sort of a parallel importing of something which is already a patent protected subject matter or a trademark protected subject matter. I don't know if it is in that context that the participant wants to know something about parallel imports, because that's where we see a lot of parallel imports that happen, right? And I really don't know how consumer protection law would impact something like a buying parallel imports.
Ma'am, you are right. Parallel imports are more related to IPR, because it's an import done without paying the proper duty to that person or a royalty to that person. And it's more to deal with business to business relation rather than business to consumer relation.
I don't know if there is much impact on buying parallel imports on the consumer directly.
Yeah.
Rather, I think, as Dr. Patil very rightly mentioned, it has more to do with the B2B transactions where they would be liable for an infringement.
Indeed, Fatima, that was very insightful. Thanks a lot. If anybody has any more follow-ups, any new questions, you can write to IGCLP, you can write to CLAP, and then we will communicate the questions to our keynote speakers and get back to you. On that note, I would like to thank our two keynote speakers, Professor Patil, Professor Srivastava, for taking out their valuable time and sitting here and giving so much information. It was honestly very important. And it was really interesting that we had one person who could give us an international perspective of things and Professor Patil who could link it back to India. Thank you also, Pratyush and Ms. Narayan for moderating and helping us out here. On this note, we would like to end this session. Thanks a lot for all viewers also to coming and joining with us. Thanks a lot.
Thank you.
Indeed, a very, very insightful keynote address and a lot to discuss and deliberate through the sessions. Thanks for laying this ground here today. Thank you so much.
Thank you, and all the best to the presenters. Thank you very much.
Thank you.